The SEC versus Ripple. When will Ripple provide updated justifications for its claims? Once the trial period is over, how much will it cost to exert? In today's video, we'll address these issues. Subscribe to the channel as we get started. For his part, Ripple's top lawyer, Stuart Alderoty, has called on Gary Gensler to step back from deciding the future classification of cryptocurrencies. According to the attorney's statements today, it is highly possible that Gensler will make biased choices in the future. To prove his point, he referenced a recent interview with the head of the U.S. Securities and Exchange Commission, in which he claimed that all crypto assets other than Bitcoin were securities. Once again, Chair Gensler has declared that all cryptocurrencies are unregistered securities except Bitcoin, because he has foreseen the outcome of the case. Stutter tweeted that he would be unable to vote in any enforcement action involving that issue. In a lengthy interview with New York Magazine published on February 23 RD, Gensler discussed the cryptocurrency market and claimed that, with the exception of Bitcoin, all other cryptocurrencies were securities due to the presence of a middleman and the public's expectation of profit from them. As a result, his comments were widely misunderstood to suggest that other cryptocurrencies aside from Bitcoin were subject to SEC regulation. According to a tweet by Blockchain Association lawyer and policy lead Jake Chervinsky, Gensler may have already ruled that all digital assets other than Bitcoin are securities, and that until the SEC establishes its case in court, it does not have the power to regulate all cryptocurrencies. Despite the commissioner's assertions that he was in charge of the cryptocurrency industry, the attorney argued that Gensler's opinion was not binding law. The community is waiting for the court to declare whether or not Sharp is a security, despite the fact that the litigation against Ripple has been going on for years and is nearing a resolution. We can't predict what will happen in this specific scenario, but we can extrapolate from past experience. As of March 2021, the SEC had filed a lawsuit against Lbry, a blockchain-based sharing platform, for allegedly selling tokens without first registering them with the SEC. But a judge on the Court of Appeals just ruled that tokens are only securities when sold in the primary sale. By demonstrating to the court, as Lbry did, that it never held an ICO, Ripple is expected to receive a favorable verdict. If Ripple prevails, it may once again be traded on major exchanges like Coinbase and Binance US, which would significantly boost the value of the token. If Judge Analisa Torres rules in favor of the SEC in the summary judgment proceeding, Ripple's General Counsel, Stuart Alderoty, has said the blockchain company will immediately appeal. Alderoty shared this insight during yesterday's chat with Blockworks. In the opinion of Ripple's General Counsel, there are three potential outcomes to the ongoing case. The outspoken General Counsel for Ripple is optimistic that Judge Torres will find in their favor when it comes to the summary judgment. Second, he said the court has the authority to rule that there are issues of material fact to be tried. In his third argument, Alderoty suggested that the Securities and Exchange Commission might receive a summary judgment in their favor from Judge Torres. According to Ripple's chief counsel, the Silicon Valley tech company will not recognize the SEC's win. If this happens, they will quickly appeal the case to higher courts in the United States. In the event that the Court of Appeals rules against the blockchain company, Ripple is willing to go all the way to the Supreme Court, according to Alderoty. He boosted the community's morale by assuring them that Ripple would prevail even if the case reached the Supreme Court. Since Ripple prevents the creation of an administrative state, the Supreme Court of the United States, in Alderoty's view, will rule in favor of Ripple. Not so much due to crypto issues, but rather the protection against the growth of an administrative state. I would agree with Alderoty that this is a triumph at the Supreme Court. Yet Ripple's General Counsel has hinted that, despite the regulatory grey area, the much-anticipated summary decision might come as early as the end of this month. According to Alderoty, the United States is not the best place to launch a Bitcoin startup. If you ask Alderoty, the best place to begin a cryptocurrency startup is in a country with clear legislation. He believes that startups in the Bitcoin industry should have relocated to a place with clear, not light touch, but unambiguous laws. Some cryptocurrency companies are considering leaving the U.S. as a result of the current climate of hostility. Actor David Schwartz reportedly hinted last month that Ripple would leave the U.S. if it were forced to, according to an article from the month before. Recently, he spoke with Bloomberg for an interview. chief executive officer of Ripple, Brad Garlinghouse, agreed with Schwartz's assessment. As a result of the United States' inability to get its act together, Bitcoin enterprises, says Garlinghouse, are already leaving the nation. He continued by saying that American-based crypto companies with overseas operations were not representative of American ingenuity. The parties in the Ripple v. Securities and Exchange Commission case have made their closing arguments and are now awaiting summary judgment, but questions remain about the regulator's authority to exercise control in the cryptocurrency industry and to unseal key documents. In the most recent development, expert explorer John Deaton has disputed a claim made by SEC head Gary Gensler, who supposedly stated that any cryptocurrency other than Bitcoin is classified as a security. The SEC is using Ripple to sell supplementary security, which is interesting to note. On February 27, Deaton tweeted that there is no agreement on how to classify securities. MicroStrategy executive chairman Michael Saylor was quoted as saying that Gensler's comments are evidence of growing consensus on the classification of security, and this prompted him to respond. While both sides are still waiting for the summary ruling, Deaton has already discussed potential settlement options. Deaton claims that Ripple has offered to settle for $150 million if the regulator rules that XRP sales, both past and present, do not constitute securities. But he added that the SEC's intensified crackdown on the digital asset industry made it unlikely that they would approve of the method. Deaton mentioned the presiding judge's ability to shed light on the secondary market for ARX rupees. It's worth mentioning that Stuart Alderoty, Ripple's general counsel, has previously implied that the SEC has very little chance of winning the case at the Supreme Court. 4 out of the SEC's past 5 cases in the Supreme Court were lost because of the few who had the will and means to stand up to the agency's misogynistic bullying and insist on pursuing overly broad legal arguments that were not true to the law, he claimed. The matter was given fresh life when journalist Rosalind Layton filed a motion to obtain the Hinman speech materials, as has been widely reported. This June 2018 lecture by the SEC's former director of the Division of Corporate Finance may provide a good illustration of the agency's classification of securities. Heinemann agreed that cryptocurrencies like Ethereum and Bitcoin are not securities, and that this logic may be extended to other sectors. Ripple has been the target of a class action lawsuit since 2018, and defense attorney James Fullen has just revealed a fresh twist in this case. Investors are demanding compensation for financial losses they sustained as a result of the company's and CEO decision to market XRP as an unregistered security in a lawsuit filed in California. Excerpt. Following what was published by Fireball, they have filed a motion asking the court to classify Extract as a security. As an amicus curiae, Deaton had asked to be included in the case. As of this most recent development, the plaintiffs have filed yet another motion to oppose Deaton's request to be joined to the case. It's all over today. Please like and subscribe my channel. See you in the next one. Bye.